We have a really action-packed and so much to talk about episode tonight. It's going to be hard to get through it all, but we've got some outstanding guests. You're not going to want to miss 1 second of this. We've got Michael Goupil, my client, courageous and victorious today in a finality of a jury trial that resulted in a not guilty verdict.
Yes. Double. Congratulations.
Wherein the jury got to hear a medical marijuana defense. Michael has been absolutely courageous in this entire event, and his wife, Cheyenne. They have dealt with unbelievable harassment, stress, and
abuse.
And this last part that they, even though their felony case was dismissed because the court ruled that the police officers violated their constitutional rights, this prosecuting attorney still insisted on prosecuting Michael on the possession of a pipe. And he's going to be calling, and we're going to talk about that. We are going to glow in victory. And I'm asking anyone to call in and join with us in this special moment where a jury heard a medical marijuana defense, heard the facts of the case, and returned a verdict of truth. That's what we're going to be talking about with Michael. Additionally, rock star attorney Neil Rockhind, who has just been thrown down all over the state defending patients and caregivers. He's going to be calling in around 9:15 to talk about his recent victories defending cannabis patients, cannabis caregivers. He's speaking at the event tomorrow at Wayne State, where he's one of the moderators. He's going to talk a little bit about that. And he had a very, very interesting ruling wherein he filed a motion to recuse a judge in a Dearborn District Court who had previously ruled that the Michigan Medical Marijuana Act was preempted by federal law. And Neil filed a motion saying we can't get a fair trial there, and the judge, of course, denied it, and another judge granted it. Nice. So Neil's going to be calling in to discuss that. We have Joe King, the CEO of the MMA, calling in. He's going to be discussing the meeting that he attended in Hastings, which was hosted by Republican Mike Colton, who was on our show and had actually mentioned this event during the show and had invited people to come from the community. Joe was there with about 250 people, I think, other people from various organizations. He's also going to discuss some of the pending bills that are being proposed and were discussed there. Specifically, he is going to be talking about the issue of legislation that would open up the law and create open up the law to determine whether or not the registry can be made available for determining whether search warrants should be issued. So Joe's going to be calling to talk about that, and also the success that's been going on with the EOmatic letter writing campaign that the MMA has been supporting. The statistics as of today were that 450,000 letters had been generated from the Michigan Medical Marijuana Association to various legislatures. So they know that we're out here. Miriam Halpern also, LMSW. Miriam's a social worker and a member of the National Association of Social Workers. She's going to be calling in. She attended a seminar on behalf of the social worker organization that she's with and wrote an article about that, and she's going to be calling in to discuss that. So we are action-packed, filled with all kinds of things. I'm going to do a quick rant. We're going to take a break, and then we're going to get right on into it. I want to talk about today, of course, the trial. Michael's going to be calling in, as I said. And today, in a way, is a culmination of a lot of things that we've talked about in the show, a lot of things that people have believed, a lot of things that people always understood the Michigan Medical Marijuana Act to stand for. In past weeks, we've always talked about the right to a jury trial in a medical marijuana case, and how when you read the law, even before the law, if you read the initial referendum and the fourth paragraph of a defense to any prosecution involving marijuana, and the general principle of the right to present a defense to a jury, and the craziness that we talk about every week of how courts are making rulings that defense attorneys are not allowed to mention on behalf of their clients the Medical Marijuana Act at all. I've talked about that. What I believe is the major issue with the problem of the implementation is just this, that if, in fact, juries were enabled to hear the facts of a case and actually hear the truth, we would not be where we're at. We would not be with a attorney general who is claiming these things. His voice would not be heard because the juries would be speaking. The community would be speaking. The criticism of this law will end when the jurors are the arbiters of the decisions, not the judges of the trial court, not the judges of the appellate court, not the police, and certainly not the attorney general. Lawyers know that the truth, albeit very, very evasive, and something that a philosopher would say, what life is about is a search for the truth. Lawyers know that the truth is very rarely spoken in courts, and everyone's got a various opinion, but there are days when the truth is found, and that's when you hear from the jury a ruling, a verdict. And it's the truth because our system is set up for that. Courts are set up to resolve disputes. Disputes are where you have people that are in conflict of fact or law. Who's right? Whoever the jury says. And when the jury returns a verdict of not guilty in a criminal case, they're saying that the government was wrong, that they didn't do their job, that they didn't prove their case, and that their efforts here did not establish guilt beyond a reasonable doubt. The fact that this has not been happening, the fact that juries haven't been able to hear the truth have been the obstacle of the implementation of this act. And I believe that in order for there really to be an understanding amongst law enforcement as to how medical cannabis is used within the community and how caregivers operate and how patients operate, it's only going to happen when the juries tell them to stop doing things the way that they are doing it. Neil may be mad at me for bringing this up, but we had talked earlier in the week, and we were discussing various cases, as we sometimes do, and Neil came up with this metaphor, which I was intending on telling him later in the show, that I actually kind of stole a little bit from him during the case today, my closing argument, and it's a very, very poignant, I think, way to look at this. And this is what's happening throughout the country, which is that you got the chickens and you got the wolves. The chickens are being monitored by the wolves. The chickens don't like the way that it's happening, so they go out and they change the law. They unite, they get a referendum, they change the law. The problem is the law is changed, but they give it back to the wolves who didn't want the law changed in the first place to monitor the law and to implement the law. And if there isn't a check or balance in that scenario of an independent body making certain that the wolves are doing it the way that it's supposed to be done, the wolves aren't going to enforce the law because they didn't like it in the first place. They certainly don't like it now. And they're certainly not going to listen to the chickens the way it's supposed to be interpreted because it's the wolves that are in charge of enforcing it. And that, to me, is the way that it is. You've got a unified group of law enforcement and, I don't know, call it court system, call it prosecutors that are not yet ready to look at cannabis differently. They've done nothing, spent no money, taken no efforts to really try to understand the medical marijuana community, believing that they wouldn't have to, that this is some crazy law by a bunch of lunatics, all 63% of them in the state of Michigan. Well, I'm hoping today in Shiawassee County, I'm hoping today in State Police Office, I'm hoping today in the FANG unit, that after taking my clients through a nightmare for 2 years, and we're going to play some of the audio from the cameraman videotape that was recording the scene, and you will hear how the state police and how law enforcement views the Michigan Medical Marijuana Act. You'll hear my client talking about how he's a patient, the caregiver, and he had less than 2.5 ounces, and he should be let go. You're going to hear them harassing him like the law was intended not to be done. And to me, today is significant because we've been talking about it week after week, that this is what is supposed to happen, that this is the way it's played out, that this is the people's law, that the jurors are the people that enacted it, that the jurors are the people that speak the truth, and when they hear it, they're going to vote in favor of the medical marijuana community. They're going to vote in favor of compassion. They're going to vote in favor of this law being prophylactic. I argued today before the jury, which I think is an important point, which is that patients and caregivers alike across the state of Michigan for the last 3 years until they are learned the hard way, have believed that the card stood for something and believed that by showing it to law enforcement, they were going to get the protections that come with it. Today in court, we presented evidence of my client's card as a caregiver and also the document that comes with it that's mailed from what was the Department of Community Health, now Lara, with this time it was Jennifer Granholm's stationery, but it outlines Section 4. It says specifically, hey, we're giving you this card. Remember that if you have less than 2.5 ounces, you get your card on you, you're protected against arrest, prosecution, or any penalty. And we entered that today because this is what the state told my client could happen, and law enforcement didn't want to hear it. But today they did hear it. They heard that they're wrong. They heard the truth spoken, that the Medical Marijuana Act was intended to protect patients, protect caregivers, and that people are sick and tired of the wasted resources that are being used to prosecute sick people, that this law was intended to take the sick people off the failed war on drugs and let them get some relief. In fact, the voters in the beginning part of in the preamble of the Michigan Medical Marijuana Act state that in enacting this law, sick people should not get arrested, and it will reduce the spending and these arrests. I can't imagine the number of man hours that went into this case, the number of times it went to court, all for what ultimately was, listen to this, 0.3 grams of marijuana. Okay? 0.3 grams of marijuana that was in an unsmoked pipe possessed by a caregiver who had 3 cards. And this is what they made him go through. So, as tragic as it is, I hope the Goupils, who are going to be calling in around 8:20, 8:30, feel better that there's some justice, that we can't trust the court system, and we have to keep believing, we have to keep fighting and taking these cases to the jury. I've been speaking about it every week. I believe juries do not want to quit. And again, like in every jury trial, there's always at least 2 people that get on the stand, get in the jury box, and are asked the question, can you be fair in this case? And you know what they say? I could never, ever, ever convict someone of marijuana. I don't care if it's medical or not. I think it's ridiculous. I think the laws are ridiculous. So we hear some truth today. We get some truth today. And not guilty is ringing true for the medical marijuana community. We're going to take a quick break. Call number is 1-347-326-9626. You're listening to Planet Green Trees. We'll be right back.